Good day everyone, I am Eloisa Ermi from 3-1 and today my topic is about confidentiality of information. What is confidentiality of information? Confidentiality of information is defined as any data or know-how that disclosing party offers a receiving party, maybe it be orally or in writing, that is meant to be private. The receiving party reasonable understand its confidential nature and any circumstances that would call for disclosure of the said information. For example, is confidential information in mediation proceeding in settlement agreement between a parties or any information may not be compelled or disclose confidential information obtained during meditation. And now let's go to the information obtained through meditation proceeding shall be subject to the following principles and guidelines. First is information obtained through meditation shall be privileged and confidential. This means that any information shared in the meditation process is protected from being disclosure. And here's are the entails. First is privilege. This means that the information cannot be used against the party in any legal proceeding. It has a special legal status that protects it from being revealed in court or other legal settings. And when we say confidential, this ensures that the information remains private and it's not shared with any outside the meditation process, only with the parties involved and meditator has access to it. Second is a party meditator or non-party participant may refuse to disclose and may prevent any other person disclosing confidential information. Number three, this means that the statement that any confidential information shared during the meditation cannot be revealed or used in the court or other legal dispute. It remains protected and cannot be discovered or admitted as evidence in adversarial proceedings. However, if information is already admissible in court or subject to discovery for other reason, it does not lose that status just because it was discussed in a meditation. In short, meditation protects what it shared, but does not change the legal status of information that can access everywhere. Number 4 is, in such an adversarial proceeding, the following person involved or previously involved in the meditation may not be compelled to disclose confidential information obtained during the meditation. First is the parties to the dispute. These are the accused and complainant. Second is the meditator. They are facilities, communication, and negotiation that assist parties in reaching the voluntary agreement regarding the dispute. The third is the council of the parties. Their rule is to give advice that they are also the third party. Then fourth is the non-party participant. They are the witness, resource person, or any expert. They are not involved in dispute. And number 5 is the protection of the ADR Act shall continue to apply even if the meditator is found to have failed to act impartially. In other words, the legal safeguards regarding confidentiality and privilege are upheld regardless of the meditator's conduct. And this ensures that the parties' discussion and any information shared during the meditation are still protected, even there are concerns about the meditator's neutrality. It emphasizes the importance of protecting the meditation process itself, even in case of potential meditator bias. And number 6, last is, this means that meditator cannot be compelled to testify about any confidential information shared during the meditation. If a meditator is wrongfully sub poena or legally summoned to court, they are entitled to have their legal fees and related expenses fully covered. This protects the meditator and maintains the confidentiality of meditation process. And now let's go to the waiver of confidentiality. First is a privilege arising from the confidentiality of information may be waived in the record or orally during the proceeding by mediator and the mediation parties. This means that the protection of confidential information shared during the mediation can be set aside if both mediator and the parties involved to agree to it. This agreement can be happen in writing or record or verbally during the meditation session. Essentially, if everyone consents, they can choose to share or disclose information that would otherwise to be kept confidential. And second is with the consent of the meditation parties, a privilege arising from the confidentiality of information may likewise be waived by non-party participant if the information is provided by such non-party participants. This means that if non-party participant or someone is not directly involved in the meditation but its presence like expert or advisor shares confidential information, that confidentiality can be waived with the agreement of the meditation parties. In other words, if the other parties consent, they can allow the non-party to disclose the information they provided during meditation, even though it could be typically protected. And the third is a person who disclosed confidential information shall be precluded from asserting the privilege under the confidentiality of information to bar disclose of the rest of the information necessary to complete understanding of a previously disclosed information. If a person suffers from loss or damages as the result of disclosure of confidential information, he or she shall be entitled to damage in the judicial proceeding against the person who had made the disclosure. This means that if someone shares confidential information from a meditation, they cannot later use confidential protection to prevent others from disclosing related information needed for a full understanding of what was shared. This disclose lead to any loss or damage for the affected party. They have the right to seek compensation through a legal proceeding against the person who disclosed the information. Essentially, it holds the individual accountable for the consequences of sharing confidential details. And fourth is a person who discloses or makes a representation of a meditation is precluded from asserting the privilege mentioned in confidentiality of information to the extent that the communication prejudices another person in the proceeding. And it is necessary for the person prejudiced to respond to the representation of disclosure. This means that if someone shares information or makes a statement about meditation that harms or negatively impact another party involved, they cannot use confidential protection to prevent that affected party from responding. In other words, if the dispute puts some in advantage, the harmed person has the right to address or to clarify that information in order to protect the right of the interest. Essentially, it ensures fairness by allowing the affected party to respond to the potentially damaging statement of disclosure. Let's go to the exception to the privilege of confidential of information. In the situation where confidentiality of information do not apply and this can be disclosed despite the usual rules of confidentiality. In these instances, individual can share or be required to share information without violating confidentiality. And first is there is the privilege against disclosure in the following instances. First is an in agreement evidenced by a record authenticated or by all parties to the agreement. Second is done available to the public or made during the session of the meditation, which is open or is required by the law to open to the public. And third is the threat or statement of a plan to inflict bodily injury or commit a crime of violence. And fourth is intentionally use of a plan of a crime, attempt to commit a crime or conceal ongoing crime or criminal activity. Then fifth is a sort of offered to prove or disprove abuse, neglect, abandonment, or exploitation in proceeding in which the public agency is protecting the interests of an individual protected by the law. But this exception do not apply where the child protection matter is referred to a meditation by a court or where the public agency participate in the child protection meditation. And next is sought or offered to prove, disprove a claim of complaint of professional misconduct or malpractice filed against a mediator in a proceeding. And last is sought or offered to prove or disprove a claim of complainant of a professional misconduct or malpractice filed against a party, non-party participant or representative of the party based on the conduct during a meditation process. Number 2. If a court or administrative agency finds or after a hearing in camera that the party seeking discovery of the proponent of the evidence has shown that the evidence is not otherwise available, that there is a need for the evidence that substantially outweigh the interest in protecting the confidentiality and the communication in sought or offered. This means that if a court or administrative agency conduct a private hearing or in camera to review a request for evidence for meditation, they can allow the disclosure of that evidence under the certain condition, which is the unavailability and substantial need. And the meditation communication is sought or offered in the following. Let's go to the last part, which is the non-reporting communication by mediator. A mediator may not make a report, assessment, evaluation, recommendation, findings, or other communication regarding by a meditation in a court or agency or other authority that may make a ruling on a dispute that is subject for the meditation. This means that a meditator cannot provide any reports or evaluation about the meditation process to a court or any authority, except for the following few specific instances. First is to state the meditation occurred or has terminated or where a settlement was reached. They can confirm that meditation took place or has ended or if a settlement was reached. And second is as permitted to the disclose under the provision on the exception of the privilege of confidentiality of information. They can disclose information if it falls under the exception to the confidentiality of protection. In short, the meditator communication is about the meditation are largely restricted to maintain a confidentiality except for these limited circumstances. And before I end this video, my quote is, confidentiality is a virtue of the loyal, as loyalty is the virtue of faithfulness, by Sir Edwin or Dr. Edwin Lewis Cole. This quote emphasizes the confidentiality is the key aspect of loyalty. Just as loyalty is rooted in faithfulness, it highlights how trust and integrity in relationship depends on keeping confidences and being committed to others. Together, these virtues create a strong and trustworthy bonds. And that's all my report. Thank you for listening.